Hello friends, in the series on the income tax cases, today we will discuss a very important case on section 148. In this era of issuing the notices under section 148, when it has become a very common practice that nowadays the notices under section 143 subsection 3 scrutiny notices are not coming to the various assessees, and whatever the assessments are being done that are mostly under section 148, and it has been seen that the notices under section 148 are being issued in a very casual manner and on the basis of the information which even do not relate to the assessee. In these type of circumstances, when the notices are issued on incorrect facts and ultimately the additions are made on some other basis which are not the part of section 148 notices. So what is the fate of these type of notices? This issue has been very well taken up by Mumbai ITAT J bench in the case of Jagadeesan Mani versus Income Tax Officer International Taxation. This issue is reported in 114 ITR Tribunal Short Notes 92 and the date of the judgment is 2nd September 2024. In the present case, the assessee is a non-resident. The notice under section 148 is issued to the assessee on the allegation that the assessee has purchased 4 immovable properties and the assessee is engaged in the purchase and sale of various shares on which the assessee has not disclosed the capital gain. Since the assessee was a non-resident, the draft assessment order was prepared and it was sent to the dispute resolution panel because the assessee has raised the objections before the dispute resolution panel, and on the basis of the objections of the assessee before the dispute resolution panel, the dispute resolution panel was of the considered view that in the present case, whatever the draft assessment order has been prepared, that draft assessment order is on the basis of erroneous facts and did not relate to the assessee. So accordingly, the dispute resolution panel in the present case rejected the draft assessment order, but the DRP suggested a new addition that was regarding the fixed deposits or time deposits made by the assessee. And accordingly, the assessing officer made the addition on the basis of time deposits made by the assessee. When this matter was before the tribunal, the assessee also submitted some additional evidences before the tribunal for the substantiation of its claim for the deposits. But when this matter was ultimately heard by the tribunal was of the opinion that in the present case, there is totally fallacy in reopening the assessment, and that fallacy could not be rectified by the dispute resolution panel, and the dispute resolution panel cannot propose a fresh addition because the dispute resolution panel in the present case has admitted that the reopening has been done on a wrong facts, and the DRP has said to make the addition on the basis of the time deposits. So the tribunal said that the DRP cannot propose a fresh addition, and ITAT held in the present case the assessing officer reopened the assessment in the present case on totally erroneous facts and on the basis of non-application of mind, which is not the mandate of the law. So accordingly, the tribunal quashed the draft assessment order and the final assessment order passed by the learned assessing officer. Friends, nowadays it has become a very common practice that the notices under section 148 are in the nature of making inquiries. They are issued on incorrect facts, erroneous facts, and when the assessee makes some submissions, then the assessing officer, by taking some inputs from those submissions, make further allegations and made additions on those points. So this is not the mandate of section 148, and this practice should be avoided by the assessing officers. So in the present case, the tribunal quashed the proceedings. At the end of this deliberation. Once again, I am repeating the name of the case. The name of the case is Jagadeesan Mani versus Income Tax Officer, International Taxation, and this case is reported in 114 ITR Tribunal Short Notes 92, and the matter has been decided by Honorable ITAT J Bench on 2nd of September 2024. Thank you, friends.